The High Court has ruled that internet mogul Kim Dotcom is eligible for extradition to the United States. This applies also to his co-accused Bram van der Kolk, Matthias Ortman and Finn Batato. Kim Dotcom himself immediately tweeted, "I'm no longer getting extradited for copyright. We won on that. I'm now getting extradited for a law that doesn't even apply." And in fact, the High Court judgment does contain a significant victory for Dotcom and his co-accused, but not enough, it appears, to prevent extradition unless they're successful at the Court of Appeal. I asked Ron Mansfield, barrister for the Dotcom legal team, to explain.
Well, John, it's like getting to the top of the wall and being knocked off once you're there. The major plank of our argument was accepted by the High Court, but ultimately His Honour thought that the allegations of copyright infringement could be dealt with under our Crimes Act, having concluded it couldn't be dealt with under the Copyright Act itself. So our argument on copyright was successful, but ultimately we were unsuccessful in achieving a successful appeal, I suppose.
Now, you and I both know what you're talking about, but I think some of the people who are listening who haven't followed this case terribly closely are going to wonder what the hell was going on. What you were essentially saying is that copyright infringements are civil law and there is no extradition under civil law, right?
That's right. His Honour has determined that the type of copyright infringement alleged here is not a crime under our Copyright Act, but concluded that it could be dealt with as a crime under the Crimes Act, which we don't agree with.
So the High Court has held that it is not a crime, contrary to the conclusion reached in the District Court. So on the face of it, that is a big win for you, isn't it?
For us it is a big win, and it takes us very much closer to achieving an outright win for Kim, which is obviously still our aim, and something which we think is achievable on the law in the Court of Appeal.
But the problem is you have that win, but then the High Court says, but hold on, you can be extradited another way?
That's right, under general allegations of fraud under the Crimes Act.
The other thing is, and this is salient, isn't it, is that the evidential requirements to get extradition are low. In other words, there just has to be a prima facie case to answer, right?
That's right, and on extradition, the United States gets to select the evidence it puts forward and craft its case accordingly. So it's very difficult to address the allegations themselves on the factual nature, so we can only really succeed on the law.
So normally when we have a trial, there is guilt, there is innocence, and there is reasonable doubt. But here with extradition, the bar is much lower.
That's right. Simply a prima facie case or an arguable case. And that's pretty easy for the United States to achieve when it gets to pick the evidence it puts forward.
So if it's pretty easy for the United States to achieve, what do you hope to gain by going to the appeal court? Because
we can win on a point of law that this is not an extradition offence that our country should be sending someone to the United States on. And that's a very important and fundamental issue for us.
Why is it important and fundamental? Can you clarify what you mean by that?
Because if it isn't an extradition offence, then we should not be extraditing somebody from our jurisdiction to another jurisdiction. It doesn't matter who they are. It doesn't matter that they're a trading partner or someone that can place commercial pressure on us. We should not do it.
And you have argued always that there was, in fact, no means of doing it because this was a civil offence being considered.
A civil offence only, arguably, no criminal offence. And that's what's been accepted, but of course the court has now concluded that he can extradite under the Crimes Act, which we don't accept.
Is that new? Has that ever been previously determined, or was it not required to be previously determined?
No, the District Court also concluded that, but the District Court made a number of errors which the High Court has upheld our criticism in relation to. So, look, there were a number of points taken on appeal, some of which were successful, some of which weren't, but the major point that we were successful on was the most important for us, namely, it's not a criminal offence under the Copyright Act, which leaves only contemplation of offences under the Crimes Act, which we say should be precluded because the Copyright Act really creates the right and creates the enforcement of the right. So it creates civil remedies and criminal remedies, and you shouldn't, and in fact we say you can't go to the Crimes Act. So there's still one step to go for us now, but we're certainly one step closer to achieving that successful outcome for Kim.
Given, though, that two-word hurdle, which is prima facie, are you really persuaded you have a chance in front of the appeal court?
Oh, definitely. We wouldn't be going there if we didn't think that. This is a case that will be won on the law. It can't be won on the facts. It has to be won on the law, and we will achieve that.
Ron Mansfield, Kim Dotcom's lawyer. Kim Dotcom himself will be joining us after 6 o'clock.